Hey everyone, this is Sunny Justice from It's a Crime and Shame. I'm just going to share with you something that came out this morning that was sent to me by Lewis. So thank you, Lewis. And if you haven't subscribed or liked, please subscribe and like to this channel. So, on November 2nd of 2022, Tobe H. Leazenby, Sheriff of Carroll County, filed a request by the Sheriff of Carroll County to transfer inmate from Carroll County Jail to the custody of Indiana Department of Corrections for safekeeping. The court, being duly advised, finds the defendant is an inmate awaiting trial and is in imminent danger of seriously bodily injury or death, or represents a substantial threat to the safety of others. This finding is not predicted on any acts or alleged acts of the defendant since arrest, rather a toxic and harmful insistence on public information about defendant and this case. In general, this court has 30 days to rule on any motion that is filed by a party in any case. See the trial 53.1. Yet concurrent to the actual case naturally occurring, this judicial officer keeps getting direct requests from non-parties for public information, claiming that this officer has 7 days or 1 day when hand delivered to respond to the request or face litigation. While this officer is responsible for the entirety of the circuit court docket, it attempts to ignore the maelstrom of interest from the public. It is known that YouTube already hosts content regarding family members of this judicial officer, including photos. The public's bloodlust for information before it exists is extremely dangerous. All public servants administering this action do not feel safe and are not protected. The Carroll County Sheriff has limited resources to conduct its base operations, let alone any duties mandated by the Supreme Court. All defendants in all actions are presumed innocent. All public information will be available the second it exists. None of the family members of the public servants are part of this action. All of the public servants are simply people doing their jobs. Most of the public servants are woefully underpaid. Most of the public interest consists of people attempting to raise their status or profit financially. When the public peddles misinformation with reckless abandon, we all are not safe. Okay. So, as far as the public's desire to learn and access the court records, the educational effort cannot be by this officer educating each individual ad hoc whenever they choose to seek public information. These inquiries are inherently disruptive to the operations of the court, as they are wholly outside the operations of the court. As a branch of the Supreme Court, any request for public information about this action should be directed to whomever is the public information coordinator for the courts in general. If there is not such a position, our state may need one. Defendant indicated at the initial hearing an intention to hire private counsel. Defendant is reminded that he must retain counsel within 20 days of the initial hearing because there are deadlines for filing motions and raising defenses, and if those deadlines are missed, the legal issues and defenses that could have been raised will be waived or given up. If the defendant is unable to retain counsel of his choosing due to the financial indigency, defendant is reminded that he is entitled to court-appointed counsel, and defendant will be examined upon request. The court notes for the public that when defendant appeared for the initial hearing, he was clad in protective gear. That protection was not to protect defendant from the court. That protection was to protect defendant from the public. Until a finding of guilt or judgment of conviction occurs in any case, judgment may be reserved and the presumption of innocence must be respected and preserved. According pursuant to the Indiana Code 3533 11-1, the court orders the Sheriff of Carroll County to transfer defendant to a facility of the Department of the Correction designated by the Commissioner of the Department as suitable for the confinement of defendant, and provided that space is available. So ordered this 3rd day of November of 2022 by Judge Diner. Okay, so requested by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the Sheriff to the custody of the Indiana Department of Corrections for safekeeping. The undersigned states, I am the duly elected Sheriff of Carroll County, Indiana. Two, the aforementioned defendant, Richard Matthew Allen, has been incarcerated since October 26 of 2022, initially at the Carroll County Jail and then transferred to the White County Jail at my request as Sheriff of Carroll County, Indiana. Three, the defendant has been charged in a high-profile case or cause, creating potential safety and security concerns because of extensive coverage from an array of various media platforms, both mainstream and social, throughout the state, the United States, and the world. Four, in that the defendant has been charged in said high-profile case, it is felt by the undersigned potential safety and security concerns exist evolving not only for the defendant but also for the jail facilities in Carroll and White counties within the state of Indiana. 5. Because of the aforementioned reasons, as Sheriff of Carroll County, Indiana, I cannot provide the services, attention, or supervision necessary to protect or meet the defendant's needs or to ensure, protect, and guarantee the safety and security of the defendant's staff or facilities. 6. Pursuant to the Code 353311-1, I respectfully request for the court an order approving and directing the transfer of the defendant to the custody of the Indiana Department of Corrections. Said agency has agreed to accept custody of the defendant for safekeeping. 7. As provided by Indiana Code 353311-5, I will be responsible for transporting and for coordinating transportation arrangements with the Indiana Department of Corrections, the defendant to and from their respective facility for further court proceedings. 8. I certify that to the best of my knowledge that this information set forth herein is true and correct. From Tobe Leazenby. And that was dated November 2nd as of yesterday. Okay, you guys, so obviously, like I said, we just wanted to show you what was out. Thank you again, Lewis, for providing me with this information this morning. Appreciate that. And I'll let you guys read it again and listen to it again if you would like. You guys have a great day. God bless. Take care and stay safe.